So good to have you. You had a lovely panel discussion. If I push you, what would be your major takeaways from that?
See, the major takeaway, as the panel was full of lawyers, is a concern that the new enactments which actually seek to replace the existing provision statutes are going to create a lot of confusion, and the recall value will be a problem. Because when you renumber the entire acts, the CRPC, the Evidence Act and the IPC, most of us would have remembered them from our law school days, are practicing for decades. Now the recall value is going to be the first challenge, and that's not a big challenge though. But the substantial changes in law and then the new jurisprudence which is going to evolve will be something which we'll have to look forward to and see how it evolves. Concerns and apprehensions are there, but I think we should always be optimistic that the courts would actually settle these issues sooner than later.
There were a lot of discussions on the lines of how a lot of discussions are taking place on the lines of AI and many other advanced technologies. How do you actually see the AI interventions when we talk about data protection, when we talk about client confidentiality? We know that we need to pace up with technology, but how do you look at in a long term, would it shape up?
See, it's going to be complex insofar as fixing the responsibility is concerned. See, as far as law is concerned, it looks at any kind of a damage or a loss caused or any harm done from a perspective of prosecuting them for damages or criminal prosecution, as the case may be. So to identify the perpetrator will be the first challenge that the enforcement would face, and a victim would also not know whom to sue, because the court would actually try to establish the guilt of a given entity or a person. So that's going to be the biggest challenge as we see. And then we have tort law, which actually has been existing for more than a century, which gives us a cue as to how you would proceed. So anyone who deploys or brings on board something which can cause harm will have to take the responsibility.
Understood. Fair point. We talk about mediation a lot. We also see that a lot of arbitration cases are going to court. Many more litigations, much more burden on courts. How do you, in your opinion, see that this can be dealt positively in some efficient way?
I see that the current model of the Arbitration Act is actually created a rung below the trial court and has only increased the burden on the litigant. Earlier, the party would have gone to the civil court or the trial court, and then the appeals would have commenced. Here you now created a jurisdiction of an arbitral tribunal, but unfortunately the Section 34 goes to the trial court, which would have exercised their jurisdiction to begin with under Section 34. So you virtually created a rung below the trial court. I think we need to have a legislative intervention where Section 34 would have to go on certain principle, either to the single judge of the High Court or a district judge, depending on the pecuniary jurisdiction, or the composition of the tribunal should also be relevant. Because we are seeing arbitral tribunals presided by Supreme Court former judges, High Court judges being actually examined by lower judiciary. See, their ability to appreciate is not in question, but I think the propriety of having these high constitutional office holders being part of the tribunals and then being actually examined and then brought through the rung of the entire judiciary again, I think is something which needs to be looked at.